Hi, and welcome to the NLHA channel, where this week we consider some contract requirements. I would say about 80% of the work that passes our office relates to contracts, whether it's the drafting of contracts, the reviewing of contracts, or even disputes in terms of existing contracts. That takes up almost 80% of the work that's done in this office. So, having clear, well written, and effective contracts um, can reduce quite a number of risks, and it will eventually save you thousands of rands in the future should there ever be a dispute in relation to a contract. So, contracts contracts can take different forms, and it, we can actually really do a long video on contracts. However, I'm not going to go into the different types of contracts and the different forms of contracts, and we will be focusing on the more basic written contract. So the first point that I would like to make is to say that contracts and agreements are normally used interchangeable, but there's definitely an actual difference between a contract and an agreement. For the purpose of this video, however, I will use the term contract. Okay, so all contracts have what we call essential elements, and for the basic written contract, the elements, if I can, I'll put up a screen, but they briefly relate to capacity, often acceptance, certainty. There must be possibility of performance and lawfulness. It must be legal. The actions or what needs to be done in terms of the contract must be lawful. For the purpose of this video, I want to go to the second phase, which relates to the actual terms and conditions within the contract, the actual provisions of the contract, where we have found over the years a lot of issues and disputes originate from. So, terms and conditions will differ from contract or will differ between different types of contracts. It won't always be the same, but from a dispute perspective, the most common areas of terms and conditions where we find disputes comes from the following. And I will also put up a screen with listing them. But like I said, it might differ from contract to contract, and it doesn't cover all the terms of conditions. This just the ones that we found in our environment causes the most disputes. So the first one is relates to terminology. Here I'm referring to the actual written words, the sentences, the terms, the paragraphs. Um, it must be kept simple, plain and simple language. I found that legal practitioners, your attorneys, your lawyers in general, they like to use legal jargon, or what we refer to as legalese, when they draft contracts, and it overcomplicates things. Not just overcomplicates things, the legal practitioners themselves overcomplicate the contracts through the various provisions. It's like if A, then B, alternatively D, and so forth and so forth. At the end of the day, because of not being clear and keeping it simple, you end up drafting a contract that contains contradictory provisions. Furthermore, clearly identifiable parties. This might sound simple, however, I've had a incident where a client entered into contact with a person and that person passed away. However, it then came to light that the son of the other party um, shared the same name and surname as his father who entered into the contract. So all the while, the son was accepting a service that was actually contacted by his father and not by him directly, which eventually amounted to or resulted in a fraudulent action. So it's very important to make sure that the parties are clearly identifiable. Stating a name and a surname and a signature is not always enough. Clear, identifiable information. Then also rights and responsibilities. Now, again, this might sound very simple, but in the negotiation and discussion of the contract, um, there's a lot of oral understanding as to what is required. However, the oral um, understanding does not necessarily translate into the written contract. So I always maintain, and although it's not 100% true, it's a good principle to have to say that if it's not in writing, um, it was never agreed to, it never happened. So what is expected of me or of the parties must be pinned down and must be in writing precisely as to what our oral understanding is. Do not rely solely on the oral understanding of your rights and responsibilities. Confidentiality is something that we also see quite a lot of. Um, this relates to the sharing of information. We now see the Protection of Personal Information Act, where it relates to this distribution and sharing of information of um, third parties. However, in the majority of the cases that we've dealt with, the confidentiality related to intellectual property. So it's very important to make sure that confidentiality is covered. Then another condition or provision that sometimes causes issues is the remedies. So parties do not, they accept the standard remedy provision that is in the contract without taking note and being meticulous when it comes to remedies. You need to consider what would happen in the event of something going wrong and the types of remedy or remedies that you need and that you are comfortable with. So don't accept remedies just as a standard, it is there and that's how it will be. Give consideration to that. Closely linked to remedies is a risk. So normally a risk are not a term in the contract. In some contracts it is actually a term. However, the parties must make sure that they are able to identify the risk and then mitigate the risk or address the risk that they've identified within the contract through a provision or through provisions. That brings me to indemnification provisions. So it's a standard thing that we find in contracts, indemnification clauses. So if you must indemnify the other party, try to limit the indemnification as much as possible. And then also negotiate the same indemnification for yourself. Parties do not always understand what the unintended consequences might be or that might arise from an indemnification clause. So if you don't understand it, rather seek legal advice on indemnification, because it might not be written there and there might be unintended consequences that flows from an indemnification. Then another clause that normally causes issues is terminations. Either there's no termination, clear termination clause, or the termination clause is very biased towards one party. So make sure that that agreements contain a termination clause, or what is also deemed to be an exit clause, outside of the normal period or the agreed upon period of the contract. Then something very close to my heart personally is dispute resolution. And we've seen now that the courts are more um, pro alternative dispute resolution, for example, mediation in arbitrations before coming to court. So it is now required that, for example, before you approach a court, you need to show that you attempted mediation. And if you didn't attempt mediation, you need to show the court why you did not attempt an alternative um, dispute resolution. So make sure that your contract contains dispute resolutions that are sensible. It's easy to say there must be a dispute resolution, or we are going to mediate or arbitrate, but be more specific as to what that entails. Um, I prefer doing sequential dispute resolution. For example, first try A. If A doesn't work, we go to B. If B doesn't work, we go to C, etc., until we get to the litigation stages or the court processes. In that way, we are able to prove to the court that we have exhausted all alternative dispute resolution options, but we were not able to, and hence the reason that we are now in front of the court to litigate the matter. Then, one that is actually also very much overlooked is the annexures or the addendums to contracts. Now, first of all, always read and understand your annexures. The question that I always ask when I look at annexures is, why is the terms and conditions in the annexure not in the actual contract? That's the first thing. Second thing is that we found causes disputes is which is preferential. So by default, we just assume that the contract, the main contract, takes preference over the annexure. However, in many cases, the annexure will take preference over the term of the contract, or a term in a contract. It's not always that the provisions in the contract is superior or takes preference. So make sure that you know whether the annexure or the terms of an annexure takes preference, and whether it should, and whether you agree with that. And then finally, also something that is overlooked, but we've had issues with it, it's signatures. So make sure that you sign the document properly. And we can have quite a number of debates regarding signatures and where to sign and what to sign. I'm saying all parties must sign every single page. Don't leave wide open spaces between where you sign and the first paragraph that you see from where you sign, so that you make sure that nothing can be inserted into that portion where words are scraped out, written in, paragraph there, paragraph each page. And also the same for the witnesses. Witnesses, in my view, must paragraph each and every single page of a contract, and not just on the last page. And the same goes for the addendums or the annexures. So make sure that signatures are properly done, because a lot of disputes arise from parties stating that they never agreed to it, that's why they didn't sign it, or similar arguments. So, yeah, in general, contracts can therefore be, or contract disputes can cause a lot of headaches. And like I said, 80% of our work relates to contracts. So it is quite worth your while to have your contract reviewed before signing it, before entering into your contract. Rather spend a few hundred rand at the start and before signing the contract, opposed to the risk of spending thousands if there is a dispute that comes from your contract and not doing your due diligence. So that's basically the gist of what we have found as disputes within contracts in our environment. If you need assistance with the drafting or reviewing of your contracts, please reach out to us. Our details is in the description of this video. And yeah, if you have any legal questions, please send them in to us and maybe we'll answer it. And yeah, thank you for liking and sharing and subscribing. Until next time, goodbye.